The distinction between real estate and personal property matters a great deal when one is involved in real estate transactions. An important factor in any real estate deal is what will be bought and sold besides the land itself. Real estate is raw land plus permanent structures on the land. This can include a house, a fence, barn, office tower, garage, or any other number of structures. But what in the house or building is included? The stove, kitchen cabinets, the toilet, light fixtures, or sink? Everything that is not real estate is personal property. Personal property is also called movable property or chattel. Real estate transactions and personal property transactions are governed by different sets of rules and statutes. Let's drill down to really understand the distinction and how items are treated in a common real estate closing. The land aspect of real estate we understand. It's the ground from heaven to the center of the earth as defined by the boundaries in the deed. The land includes whatever grows on it, like trees, grass, and naturally occurring animals, like deer or duck. The land also includes whatever is underneath it, like mineral deposits, coal, or oil. The rights to these things, especially mineral rights underneath the land, can be sold to other people. The land or any structures can be leased out to tenants. Rights to easements can be granted across the land. Real estate is land plus fixtures. Fixtures are things attached to the land or improvements made to the land. The technical term you'll find in deeds and contracts is appurtenances. Fixtures generally cannot be removed, at least not without significant damage to structures or the land itself. Fixtures include buildings, plumbing, wiring, built-in cabinets, and sometimes appliances. Fixtures also include wells, underground storage tanks, sewer systems, and mines. Whether something is a fixture or movable property is a legal question. A handy tool to determine whether something is or is not a fixture is to apply the mnemonic device MARIA, M-A-R-I-A. M is for method of attachment. How is the item attached to the land or structure? A house usually has a foundation that is dug deep into the ground. A well is dug into the ground and surrounded by brick or concrete. A barn may have a small foundation, but certainly cannot be moved. There is no question that these are fixtures. Pipes are built into the house and attached to the local sewer line. Electrical wires run throughout the house behind the walls. Cabinetry in the kitchen is securely nailed to the walls. A fireplace is built into the structure. A sink is glued into the countertop, which is, in turn, glued to the wall or attached cabinets. These items can be physically removed if one tries hard enough. In fact, when banks or new owners entered many foreclosed homes, they found the copper wiring was removed, just ripped out of the walls. Copper was fetching a high price on illicit markets, and former owners wanted to cash in as much as they could after leaving their property. The phrase, "take whatever isn't nailed down," was taken to an extreme. Most people would agree that these methods of attachment, being built into the walls, establish a fixture. But a light fixture can be screwed into the ceiling. A television can be mounted on a wall, but easily removed. These items are questionable, and we must look at other factors. A is for adaptability. Is the item custom built for its space? Can it be removed and adapted to a different space? Kitchen cabinets likely cannot be adapted to another space, nor can they be removed without significant damage. However, a mobile home, while heavy, can be moved without damage to a new space. Similarly, a television, even a wall-mounted unit, can be adapted to a new space with a new mounting. Pipes and wiring are made and installed in a way that fits the building where they operate. While individual pipes could be removed in certain places, removing all and using the same ones in another structure would be extremely difficult. In the case of pipes, cabinets, and electrical wiring, we are likely to say that those are fixtures. However, since a television could work in any house unless it's physically built into and made a part of the wall, it will be considered movable property. Light fixtures always present an interesting problem. An expensive chandelier isn't something a discerning homeowner wants to leave behind. It may have been purchased to fill that particular space and installed with great expense, but it can be removed and placed in another living room in another house. It is adaptable. However, recessed lighting, while also a light fixture, usually cannot be removed and adapted to a new space. New holes would have to be drilled into the ceiling, and the original home will be left with empty holes. That makes a house far less marketable or desirable. Similarly, the HVAC units for the home may be a questionable item. In-window or in-wall units are fairly easy to remove and are not adapted for the space. However, a central air conditioning or central heating unit with the operating unit outside the building, but the ductwork inside the walls is more likely to be considered adapted for the space and not adaptable for another building. For questionable items like light fixtures and appliances, we have to look at the next factor. R is for relationship of the parties. If there is a dispute between the buyer and seller on whether an item is a fixture or personal property, courts will generally favor the buyer's opinion. For example, let's say there is a contract for the purchase and sale of real estate that says the sale includes all fixtures. In the house, there is a $6,000 Viking stove. When the house was shown, the stove was present, and it was present in all advertising photos. The buyer purchased the house thinking the stove was included. After the closing, when the seller is moving out, he attempts to load the stove onto his moving truck. The buyer brings the seller to court, demanding that the stove be left behind because it is a fixture and part of the sale. But the seller says the stove was not built into the walls, simply plugged in. It was not custom built for the space in the kitchen, and it can just as easily fit in his new house as his old house. In jurisdictions where the courts favor the buyer on these close calls, the buyer will win the case. Why? Because appliances that look built in and presented as part of the house can be fixtures, and the seller should have been more specific in the contract about what was and what was not included. Similarly, with expensive light fixtures, other appliances like a refrigerator, air conditioning, and heating units, the question of whether they are fixtures or personal property may end up hinging on the court's interpretation of these ambiguous items. I is for the intent of the seller. When the seller installed the item, did they intend for the item to be permanent? If so, it will most likely be determined that the item is a fixture to the property. For example, if a seller installed built-in bookcases and custom shelving, it is plausible to assume these items were intended to be permanent and therefore considered a fixture. Which brings us to the final letter, A. A is for agreement. The most important factor in determining whether an item is or is not a fixture is the written contract between the parties. If the agreement says that the stove is a fixture and it is included in the sale, then so it is. There is no substitute for a thoroughly drafted, complete, and understandable contract. While there is a movement to simplify written documents to make the process look easier to clients, it can ultimately cost clients thousands in the end. Many states have form contracts prepared by attorneys or local real estate broker associations. These form contracts are valuable tools because they keep up with the latest trends in case law and are edited each year in response to better understood needs of agents and clients. However, they're not meant for every situation, and they can be general or vague, particularly about fixtures. It is the agent's responsibility to sit down with the parties and fill in the blanks. Ask what will or will not be included in the sale. Appliances, furnishings, a storage shed, light fixtures are all things that are questionable and negotiable. A few extra minutes going through these details will save both parties and you months in court. If something is not a fixture, then it is personal property, or chattel. Personal property is goods that are movable, or immovable but are not real property. Personal property is governed by a different set of laws than real property. The most common personal property in real estate is furniture. Everything from the bed, couch, lamps, and rugs to electronics. If you can carry it away, it's certainly personal property. Certain appliances may be personal property. For example, a microwave that is not built into the wall is personal property. A refrigerator is likely personal property. The washing machine and dryer are likely personal property. A smoker out in the yard, a playground, or storage shed can also be personal property. Whether or not personal property is included in a real estate transaction depends on the contract. As we said before, it is wise to go through the house and decide what will and will not be included in the sale. Many homeowners don't want to carry a refrigerator or pay the cost of moving a washing machine, so they'll leave it behind and add value to the price of the house. Owners that are relocating to smaller apartments will usually leave behind furniture that fits a house but not a small apartment. But to make sure there is no confusion, include in the advertisement for the property and the contract exactly what will stay when the sale is complete. The different rules around real and personal property play out in the foreclosure context. Many of the properties on the market today are houses that were foreclosed during the recession and are being resold by banks or other investors. When real property is foreclosed by the bank, it only covers the real estate. Personal property is still the property of the prior owner. Foreclosure does not include furniture, the television, or the piano. Often, after a foreclosure, the bank that buys the property has to institute an eviction case to remove the prior owner and their belongings. If the prior owner disappears and leaves behind their clothes, pots, and furniture, after a period of time, that property can be deemed abandoned. The bank is stuck with it and will pay for a removal company to take the items out and dispose of the personal property somehow. Different rules for personal property also apply to liens. Liens for real estate are recorded with the real estate clerk of the county where the property is located. However, Liens on personal property are usually in the form of a UCC-1 statement. A lien on personal property is usually placed when the item is bought with lender financing. This is common with furniture and expensive electronics. If the owner doesn't pay according to the terms of the loan, the lender uses the UCC-1 statement as a basis to file a lawsuit and take back the property. In commercial property, fixtures are treated differently than residential property. In residential property, it is expected that fixtures like cabinets, lights, and appliances will remain with the house as fixtures when the property is sold. In commercial property, unless it's specified in the contract, the new owner expects to take the property almost as an empty shell. That means all fixtures are removed. Fixtures in commercial property are usually referred to as trade fixtures. Trade fixtures are considered personal property and are usually removed when a building is sold or a lease term is completed. Trade fixtures typically include display counters, manufacturing equipment, computers and servers, registers, store shelves, business signage, sales racks, and even ceiling tiles. Trade fixtures are usually specific to the business that operated in the building. If the previous owner manufactured metal fittings, then the hair salon moving in will have no need for the equipment and won't want to incur the expense of removing and selling off the manufacturing equipment. Similarly, the clothing store that follows the hair salon will have no need for barber's chairs, mirrors, and stylist workstations that were used by the salon. Another reason trade fixtures tend to be removed when the prior owner moves out is that the trade fixtures often have a lien on them. Many commercial loans, whether for real property, personal property, or revolving credit for operating cash, include a lien on all trade fixtures. The business owner will need the trade fixtures in his new facility both to continue his business and to serve as collateral for future loans. An interesting question with commercial property is whether the HVAC unit, usually found on the roof, is a trade fixture to be removed or a part of the permanent structure. In this case, it is best to go back to A, the agreement. Careful drafting of the commercial real estate contract is crucial. While a home in-wall air conditioning unit may cost a few $100s, commercial-grade HVAC units cost tens of thousands of dollars, depending on the size of the building. Similarly, with trade fixtures, it is important to draft an agreement that accounts for all of the existing fixtures and improvements made to the building. Sometimes, the new owner will want the building restored to its original condition. Sometimes, simply removing the trade fixtures is enough for the new owner. While your local real estate agent association may have pre-printed agreement forms for commercial real estate transactions, it may be wise to enlist the assistance of a local attorney who can draft an agreement that will set out the intent of both parties. So far, we've discussed residential property, commercial property, and industrial property. But what about farms? More than half of the United States is farmland. Anyone working outside of a city will encounter farmland transactions at some point in their career. The differences are stark. The acreage will be considerably larger, but there will usually be a house with usual fixtures. A farm transaction also has outbuildings that may or may not be fixtures, depending on how they're constructed. The barn, chicken coop, smokehouse, equipment shed, and grain silo are all likely to be considered fixtures that remain with the property. Tractors, threshers, and other equipment will usually be considered movable property. But farms bring up a special issue of personal property: emblements. Emblements are crops, seasonal and annual plantings. Emblements, while physically attached to the ground, are considered personal property. Crops does not just mean wheat or soy. Crops include apples, strawberries, potatoes, and anything else that grows above or below the ground. On land that is used to harvest wood, the trees themselves are also a crop, considered an emblement. They are the personal property of the farmer or cultivator. The unique status of emblements is a consequence of the history of farming. A farmer who owns the land and plants his own crops keeps them as his personal property. Crops can be pledged as collateral separate from the land itself. Even future crops, those not yet planted or harvested, can be pledged as collateral. The lien is similar to other personal property. The right to plant and harvest crops can be leased or sold to another person. In other words, one person can own the land and another person can plant crops, harvest them, and sell them. This is because the crops are separate, personal property from the land itself. Issues arise with tenant farming. A tenant farmer rents the land from the owner to cultivate crops. The crops should be the property of the cultivator, namely the tenant. But the landlord usually has a lien on the crops. And it's not uncommon for the tenant to give some of the crops to the landowner as part of the rent payment. When there is a disagreement among the parties, questions arise as to the ownership of the crops. The owner claims they're on his land. The tenant says he cultivated them. A court would have to go through a lengthy analysis to make a final determination of the status of the crops. A lucrative business in many regions of the country is timber farming. In the South, pine and bamboo forests are very popular investments. An investor would buy the land and sell the rights to the naturally growing pine trees on the land. The owner doesn't really have to do anything. There's usually no planting. The harvesting is done by professional lumber companies who pay the landlord for the timber by the ton or by the acre.